a person affected by, let's say, cartelization has a right under 53N to come to combat for damages, compensation, etc. Now, there seems to be no, as per law at least, I'm sure, the law does not say that if you avail of the leniency program, you are also free from obligations under 53N. So the civil action, which is with an authority other than the regulator, it's not even with the civil courts here, it's with an authority created under the same act under which a competition commission has been created. And that has, and these powers of compensation have not been taken away by any leniency program under section 46. So there's an additional complication here. And during my discussions with a lot of people, the directors, the legal counsels, have voiced this reservation against the leniency program on two reasons. One, the lack of predictability in the leniency program, because though your disclosure, as Smita said, had to be complete, of value, etc. And you may think that assessment, whether it's the disclosure is complete and the value, etc., is to some extent subjective. So there is no predictability what kind of waiver are you going to get. And the second reservation that they had was this interplay between section 53N and the 46 of the Act, whether if you come under the leniency program, whether you put your liability under 53N also gets mitigated. In fact, if I'm not wrong, EU tried to address that issue, that when there is a leniency program availed of, the civil liabilities, how they would be worked out. There is criticism even for the system that they have worked out. But in the Indian situation, I think we do need to dispassionately first analyze whether our leniency program is really working, and secondly, to see how we can improve it, whether learning from our own experience or learning from international experience.
Thank you. Well, taking a lead from what our chair just said, one of the major issues when it comes to leniency is with regards to confidentiality. Confidentiality of the identity of the person who is making the disclosure, identity throughout the process, and of course what is being disclosed. And finally, when it comes into adjudication by the Competition Appellate Tribunal under 53N, whether or not the disclosure itself would be available to before the Competition Appellate Tribunal. Now, how our lesser penalty regulations work, there is what could be considered as a blanket confidentiality that is given to the leniency applicant and the disclosure that is made. So, Mr. Chingal, how has the CCI addressed issues with regards to confidentiality?
Current confidentiality is something which I think we, not only in the CCI, even the DG office, we are grappling with literally. Typically what happens with the leniency applicant is the application is filed and the leniency applicant says, thanks to Regulation 6, you cannot identify me, you cannot part with the information I have given you, and that's it. The DG now is in deep trouble because he doesn't know what to, he has to further get information from the other cartel participants to move ahead in his investigations. The cartel participants tell him, okay, what is the charge against us? Why are you asking us all these questions? Am I a witness in this case? What is it? Then the DG normally gives reference to the case number and they come running to the secretariat asking for inspections. What does the secretary do? I have nothing to share with them because the leniency applicant has been given confidentiality under regulations, under the MP regulations. So we have a nice formatted letter which we turn around and give all of them. Many people in this room must be used to that letter, which I sign and give you, and you smile and go away and you understand this is a leniency case. And then after that, what happens is that we have writ petitions in the Delhi High Court. And everyone says before the court, look, sacrilege, see what the CCI is doing. Imagine they're not telling us. Slowly over time, courts have also understood that this is a particular architecture under the Act and there's something called a LP program. That's fine. But what is very interesting, and I mean no offense to anyone, interestingly the legal firms or the practitioners who are OPs run to the court asking for that they're not being allowed inspections. And then the next day they come as LP applicants and say, there you show my papers to anyone. You know, here I am and here's Regulation 6 and I'm not ready to give you a public version of the information that I filed. So it's very interesting. But maybe these are early days and somewhere we need to solve this. The Commission is totally seized of this matter. Also under the regulation, I don't know whether we will resort to, the regulation, Regulation 7 under the lesser penalty, or we maybe think of amending the regulations. But we have to bring in that one stage when the DG, at least qua the parties, would have to share the information. Maybe that information would have to be, and the LP would have to cooperate. And again, I come back what I said just some time back. We should not forget that the section per se. We are governed by section 57 and then again 46. And 46 says, please cooperate with the proceedings throughout in order to get you up to 100%. So I think also, and this is my personal view here, that when you turn around and say, no, I'm not going to part with anything and I have the right under Regulation 6, you have to think how far you go cooperating in the proceedings. So somewhere we will have to disband this confidentiality. Of course, how are we going to go about it? What part of it will have to be given up? What will have to be shared will of course have to be worked out. Of course, the architecture also has to be worked out. Luckily, we can bring this in through the regulation, that is with the CCI. And the Mali order, probably very soon we will come up with something. And let's see, maybe the easier course is to look through, amending the regulation rather than going to the Act. So that is the problem with confidentiality, the way I look at it from the Secretary. The DG, of course, would have a different take on it.
As Ma'am Kapoor has said that if we see the annual report of the Commission, there is no case where LP matter has been resolved, and that is the fact of the matter. And we are grappling with the challenges of LP Regulation 6, which grants confidentiality to the identity as well as the information submitted. But if we see from the perspective of sections 57 and for the other participants who are not the LPs, then it becomes very challenging, particularly when the LP is not willing to waive the right of confidentiality. And even I believe in EU at this stage of the issue of a statement of objections, the confidentiality is completely out of gear, and everybody is aware of the things. So now the call to be taken is at what stage it is to be given up. Whether the DG has to prepare the report based upon the information available with him, what the LP has given, what the third parties have given, and depending upon the evaluation of evidence available with him from the OPs. And then the Commission gives a copy of the report to the parties, and then it is opened up for cross-examination or confrontation of the whatever evidences have come during the course of investigation. So these are the issues which are unresolved as of now, and I will say if the CCI is a young jurisdiction for the perspective of the competition law, for the LP matters it is really nascent. Probably the legal fraternity, all the stakeholders have to think about how to take it forward further. Whether the right of cross-examination, as we were discussing in the morning in one session, is so important at the stage of the DG itself, Or is it important at a later stage when the report has been submitted and then inquiry is going on? So we have to sit together probably and find out solutions for this. And until these solutions are found, we are bogged down in the procedural things only and not able to carry it forward. Probably that is my take on this as of now.
On the confidentiality.
On the confidentiality bit, I just would like to add, most often we do criticize the CCI on issues of confidentiality, but at least I think so far as leniency is concerned, they have taken, I would probably believe, which is the right stand, at least before the DG stage, not to disclose it, so they can come out during the course of the investigation. Parties can submit whatever information have. I say this without prejudice because even in one matter, I find it challenging the validity of Regulation 6 itself for the High Court. But I think at least in a matter of this nature, at least when you're looking at leniency petitions, it is better that the matter gets investigated and you provide the information. So without, as an honest panelist over here, I'd like to discuss probably that is being done. What you can also look at is, I hear good words that probably at a later stage, when the DG report does come out, if the confidential information is actually disclosed, that may probably make the system work better. Another thing which you could probably consider is, I believe in the US, in trade remedy measures, what they do is the lawyers are given the confidential version and they will give an undertaking saying that this is not going to be disclosed to the clients. So at least the lawyers will have an idea of how or what is the case that they'll have to meet. So it gives even on a level playing opportunity both the lawyers as also the regulators to see how we can best work out the system. So just a few points on the confidentiality.
Thanks for that. I'm sorry we've skipped the call on competition compliance and gone into leniency, but we'll come back to that. But Andrew, let me get your thoughts here. Your client has a robust compliance program in place. They detect that there is possibility that there was cartel or some information exchange that took place that could possibly infringe competition law in India and elsewhere. But you don't have time to do a full forensic analysis, etc., to really come to give, as the secretary said, the full, true, vital information. Right? And you have 15 days. Could you sort of give us from your practical experience any instances where timelines and how those have been played and how jurisdictions abroad are able to harmonize both the balance of getting all the information with the timelines to meet and get a marker?
Sure. So this is an instance or a hypothetical in which it really is imperative that there be some sort of compliance program already in place. And we can talk a little more later about what may happen if that's not true. But it is absolutely cannot be overstated the degree to which time is of the essence once you receive that there is an indication that there is a problem. Now, if you're lucky, that indication is coming from within your own business and not coming from a regulator who has already taken a close personal interest in the well-being of your client's executives' lives. So it's clear that in order to be eligible for leniency in almost every jurisdiction I'm aware of, you will need to be able to provide real substantial evidence capable of assisting the regulator in prosecuting the enforcement, which means you will need to be able to provide very detailed proffers about who did what with whom. You'll need to be able to provide exact details and dates of conversations. You'll want to be able to provide documentary evidence. There's a million things that will need to be shown to the regulators in order for them to feel that you are cooperating, in order for them to feel that you have provided the type and quality of information you need to benefit from really the enormous benefit that leniency can provide depending on the jurisdiction. And as was alluded to earlier, there are jurisdictions such as the United States where there really is only one slot. The Department of Justice makes it clear that there is only one successful leniency application per conspiracy. So with that in mind, time really in which you can get that in front of the regulator must be balanced against how much information can we get. You'll want to go in as fast as you possibly can, because even if you are late by a matter of an hour or two in the US, your client could be out of luck. That can make a difference of, just to take a recent example in the EU, you had the leniency application in the trucks cartel would have been on the hook for $1.2 billion fine. And instead, they were fined nothing because they got in first. In the US, it's all or nothing. So you get in first, it's 100%, and you get in second, it's 0%. And so what does that mean practically? So what can you do? How can you balance that need for a real intense, thorough investigation with the practical effect of getting your marker in? Indeed, you may not even know within the first hours or day of having learned this information if your client actually did anything wrong, right? You may get indication of a conspiracy. You may get evidence that some sort of bad act is happening in the service sector, in the product sector, and not even know if you've contributed to it. And still, you want to be the first in, as I say. So what do you need in the US? And I'll talk a little bit about the US and about an emerging jurisdiction like China. So even though you may not have all of that information, you need 4 things for the US in particular. You need to be able to report that there is new information and at least the possibility, new information that the Department of Justice did not already have, and at least the possibility that your client committed a violation of criminal antitrust law. You will also need to be able to disclose the general nature of what you have learned, and you will need to be able to identify the industry or the product area in terms that are specific enough for the regulator to know that you are indeed first, right? You can imagine that if there are investigations going on in a general sector, say auto parts, right, or pharmaceuticals, it's not enough to go in and say, hey, we've got, we've smelled a hint of smoke that there might be something in auto parts, and we'd like leniency. I don't think you're going to get a successful application marker down for an area like that. You need to be specific enough to show that this is somewhere that has not been investigated before, that there is some information that you really are first. And so you can't go in completely blind, right? You may not be able to go in with that very detailed information, but you do need to know enough, and your client needs to dig enough to be able to narrow it down to defend your claim to being first. And then in the US, you'll also have to identify the client. It would always be nice to be able to go and say, hey, I've got a client that thinks they may have broken the law, but I don't want to tell you who it is. And the DOJ won't cotton to that. Can be a very different process in different jurisdictions. Most mature regulators have a system, that sort of marker system that is similar to that, but in China, the situation is completely different. And this can be something that can be brought out in more discussions, but where you have a leniency program that has been proven over time to be effective, where there's the trust of lawyers and clients that it will be used in the right way, that it will be what you have been promised will in fact happen, then these programs become very effective, right? These are the programs where 95% of the cases, 90% of the cases lead to cartel convictions. If you don't have that confidence, or if there is too much discretion in the hands of the regulator, then there won't be that confidence and people won't use the system. So in China, conduct investigations can come under the heading of one of 2 regulators, either the National Development and Reform Commission, the NDRC, or the State Administration on Industry and Commerce, the SAIC. Theoretically, there is a difference in their scope and their ambit of power because the NDRC is supposed to look at pricing and the SAIC is supposed to look at non-pricing. But of course, everybody in competition knows when you get down to it, everything is pricing. So it's always difficult to know who you're supposed to apply to in China. And there are meaningful differences in their leniency programs, which means if you don't know who to apply to, you may be getting a different deal depending on where you go. If you apply, for example, to the NDRC, they have a rule the same as the U.S. that says if you're a ringleader, if you are the real bad guy who coordinated everything, you can't have leniency. The SAIC doesn't have that rule, right? If you go in the NDRC, they have, again, sort of the 100%, 50%, 30%, and thereafter rule, which is familiar to the CCI. The SAIC has a much more discretionary rule, which says 100%, 50%, and then we'll decide thereafter. And so in the terms of a marker, when you're going in with that information, in jurisdictions like China, you may not know who to go to. There's not this very clear idea about how much is enough to get in, to get your marker down. And you're not sure what your marker is worth. To bring up a final point, and to touch on what was discussed earlier, confidentiality also becomes an enormously important factor for companies to consider in terms of, will I even make a marker, right? Do I even want to put my information down? In many jurisdictions, that sort of information is scrupulously protected. In China, we have honestly seen confidential information put in as part of an application for a marker, pre-leniency information that was submitted has shown up in a graphic on the CCTV news at night. So literally the front page of an application is on the nightly news, blasted out to 1 billion people. So those are all things that you have to weigh on a practical basis when you decide, am I even going to go talk to the regulator?
Tina, I know you have some comments, but also I'd like to ask you a question following from what Andrew just said. In the US, you get immunity for conspiracy, and there's also that you have to be quite specific on the products that you say will be generic. Now, there is a concept of EU for single and continuing infringement. So, if you could talk a bit about that, and of course your comments.
Your turn. Thank you, Karan. First, would you allow me to stress something that Andrew has said? Then I would like to tend controversy, and then if you haven't forcibly removed me from this panel, I'll answer your question, which is, as incentives go, I'll do it in that order. The first thing is, I want to stress something that Andrew said, consistency. And I agree with timing sometimes being very stressful, and there's never enough of that rare commodity, but you simply cannot, go in one jurisdiction in what is a global economy, and I think most of our clients live in a global economy, and take a decision for one jurisdiction without having a strategy in place, really, for all the jurisdictions. Some of those may be, different in terms of how they work from others, but you just have to be, ready for a consistent approach across jurisdictions, often pretty much concerted around the same time. If you don't, and there are legion examples of this, you can find yourself the heavy winner in one jurisdiction and then get fined in others where other companies simply were quicker, maybe even after you alerted them through your initial filing. That, by the way, is true not just for one product and one, across jurisdictions. It's also true for related products or similar issues in other product areas that a typical conglomerate gets themselves into. And it all goes back to a compliance topic we started this session off with. If your company or if your client has a serious issue of how to behave competitively in one of its areas, it's not entirely unthinkable that maybe it's similar in other areas. And most of the big, what I'll call investigative families, started with one product, and then companies started cleaning up shop. And we're doing today investigations, capacitors, resistors, which were spawned by DRAM. And DRAM is a case which got started in June 2002. So we're 14 years, and sort of, it's not even the grandchildren, it's the children of the grandchildren of DRAM are under investigation with a range of decisions still out there. So that was my stressing what Andrew said then, the tempting of controversy. I agree it may be a race, and time is of the essence, but only rarely so. Let me try to explain that. So if I come across one of those nice old-style round tables, smoke-filled room, smoking gun evidence that people went to exotic resorts where they had loads of discussions at the bar, maybe they had a fig leaf to get their expenses paid by the company, where they were looking at some boring statistics, but then at a big lunch and a closed session, and they did that for months, and it does look like a good old price fix as we love them. Well, then I would agree, if you're first, you're lucky, rush in and make sure you don't get hit. Anything else, and there's quite a bit of anything else if you think about it. Take Europe. So we're saying here's a price fix, it's a cartel. We're also saying information exchange, which is something much harder to put your hand on, is exactly the same, at least in terms of the biobject standard that we use, information exchange. So this is talking about stuff bilaterally. Am I going to rush in? I discovered this. Am I concerned about it? I sure am. It's competitors talking, right? Competitors talking makes me concerned. I am an antitrust lawyer. Am I going to rush in straight away? No, I am not. I am going to think, and I'm going to think twice and probably 3 times and get to the bottom of it. Because if I rush in, as I do think many of our Japanese clients have done at the start of the audit parts investigation, feeling that maybe it was a cultural thing, it's obligatory to cooperate with the regulator and thinking they have to do that under leniency. I think they admitted guilt where the fact sets were so specific that maybe, if you looked at it from a slightly different way, maybe it wasn't quite a cartel, but once you're in that process, it gets a life of its own. And then, well, you pay those horrible fines, your executives, if you weren't number 1, go to jail, and then there's the real horror, which is the civils at the end. So I think unless it's all clear-cut, before I rush in, think twice and then think again. And then finally, to answer your question, the single and continuous infringement and how to deal with a product mix. Oh, this is very difficult. We do have a formal single and continuous infringement standard in Europe. The Commission has used that to bridge gaps in its evidence, to really, I think, avoid having to establish, well, these folks didn't participate for 1 month in this 3-year running cartel. So clearly, it's only that last part, which is shorter, and time is a factor that matters when they calculate our fines, to, pardon my French, avoid all the bullshit arguments. There's single and continuous infringement to bridge certain gaps and also to tie together products which are closely related. The problem we have in Europe, and Richard, by all means, feel free to comment on that. My feel is the courts have backed the Commission all the way to an extent that I think the single and continuous infringement has grown to such proportion that there are very few checks and balances, and you kind of wonder whether it's all really part of one interlinked infringement. In the end, of course, it's all about the facts. But I do think if you're looking at different products, go in and apply. If you decide you need to apply for leniency, apply for separate products. One very final point, we have one gap, I think, in our amnesty leniency program. We do not have Amnesty Plus. So you don't get an extra bonus for that if you're under investigation in one product, if you deliver others. I do think that is something which is very important. Leniency programs, the more sophisticated this all gets, the more strengthening they need to continue to be a success story. Amnesty Plus is a great thing. In so many ways, one could even see it as a compendium of the single and continuous improvement.
So I know time is running out, so I'm going to ask my last question on leniency before we skip to the nutrition purpose of settlements, which is not being spoken about in much detail. To Mr. Cook, when increasingly the CCI, the DG office has been looking at the liability of individuals, and that also ties in compliance and how do we mitigate that risk. The lesser penalty regulations are silent on whether or not the extension, if you get a immunity from the commission, whether or not that would extend to the individuals under 48. Now, as investigated, because the same as a lawyer, I would think if I'm in vicariously liable for the enterprise, so if the enterprise is getting something and I'm the one who's directing the enterprise to make the leniency application, I should also get that immunity. Your thoughts would be
I think the orders which the commission passes includes the subsidiaries, if it is a foreign company, the subsidiaries in India, and the key personnel who are the key personnel who participated in the cartel thing. So by that logic, they will be getting benefit of leniency to the extent up to 100% or 50%, 30% as the case may be. That is my personal opinion based on the orders which the commission has been passing.
Thank you, sir. Just like to add to that, sir. This has been a session that's been doing the circuits for quite some time. The directors and others would get the benefit of leniency. I think the legal basis of the premise is available under Section 27, as also under 48 itself, because it says, it's as you said, it's the provision for vicarious liability, and it is a vicarious liability which is being fastened upon the person concerned. So when you say that the primary company itself is going to get the benefit of a leniency, naturally they will also follow through to the director. And as it is, the commission has powers to pass restitutory orders under 2017. So I think that should have the basis for the commission to provide directors and other persons also the eligibility for getting leniency.
Thank you. So as Ma'am said, we don't get to see the 26-1 orders very these days, so maybe that's why that has escaped. Now coming back to settlements, so then I'm going to go back to you. If you could, for the benefit of the audience, to perhaps discuss what was the basis of the Madras High Court to come to that view, and then discuss the perspective on settlements, how they can, there's a legal basis for that in India.
Okay. Thanks, Ben. Now, all of us are aware that there was a case that was filed against Kamal Haasan, and he came up with the Shrukam movie. And they were, he wanted to go out with the movie on the DTH platform itself. And there were certain DTH platforms and other operators who were prohibited from operating on that particular network. So that's the reason he filed the case before the Competition Commission, not providing the opportunity to have this movie being showcased on that particular platform. But of course, during the course of the proceeding and the investigation, the parties did come to a settlement. There were a lot of other issues in terms of the other parties alleged fraud and saying that the documents were forged, etc. But the parties ultimately came to a settlement. And that was before the Madras High Court, because Kamal Haasan and his company, they wanted to watch the overall proceedings and the criminal investigation that was being initiated by the other side. So during the course of the matter, one of the key issues that came up was, is it possible for matters to get settled? Because the commission has been taking a stand principally that once a prima facie order has been passed, irrespective of whether the parties do want to settle the matter, the commission has the power to proceed with the matter. But the Madras High Court came out with the view in that particular case, which is also now being followed as Sarvagno in the eyeball case as well, to a limited extent. That once the parties do come to a settlement, the only issue that remains for the commission to look at is the issue of penalty. That's the only issue. Of course, the commission has to take into consideration whether the settlement is actually going to have or continue the anti-competitive conduct. So once that is being determined, I don't think there is anything there. So on that basis, in terms of section 27G, which I referred to a little while ago, the Commission, the Madras High Court clearly pointed out that settlements are permitted within the framework of the Act. Now, when you look at it even from a logical perspective, the idea principally is to ensure that there is a competitive level playing field and companies are able to operate in a competitive manner. On one hand, you have lesser penalty regulations and leniency, which allows companies to effectively settle or get a closure to their matters. On that basis, on the same logical premise, I also believe that settlements should also be permitted, and I would request and welcome the Commission also if they could take this approach, because we also understand that a large number of cases are being held up before the DG and before the CCN, and the Commission is hard pressed already with a lot of matters. So this will enable the Commission, in fact, to settle these matters and devote the resources, in fact, to other matters which could probably be more contentious, which could develop probably issues which are of importance to the markets, as also from a regulatory perspective.
In fact, I want to raise a question here. Leniency program is before the DG has submitted its report. Okay? And the settlement, if you go for 27G, 27 starts with contravention has been established. So if you put them at the same pedestal, leniency and settlement, then you're going to kill the leniency. Because if settlement can get you the same relief, then why would you go for a leniency? You will take your chances, you will wait. At some point, if it gets detected, we can fall back on the settlement process. So if you are thinking of putting leniency in settlement with a similar kind of a framework, then in my personal view, this is inviting problem. That's why probably EU said that while leniency you can get up to 100%, in settlement you will get 10%. So if Commission, I don't know what view Commission took on that Madras High Court judgment, whether they, because it was sent back to them. And if we are going to look at a structured settlement program, I think we need to clarify how the settlement is going to operate and to what extent the settlement will mitigate your penalty.
I just like to add to that. In fact, it's a good point you raised, ma'am. My point principally was settlements should be allowed, and is there a legal basis at this point in time? But I'm also the view it makes it much more better if you have circulars or field notices. Like, I'm sure ma'am is aware that in most tax matters where you've acted as commissioners, etc., there are field notices or circulars being issued. This will not really be statutory notices, but at least gives a basis for the commercial and business community to have an idea that this is the way the Commission is going to look at these things. So if one, of course, the best approach is maybe to issue regulations under 64, if that is possible, if the Commission is inclined to do that. Otherwise, at least as a via media to begin with, issue some kind of circulars. So it comes within the purview of the business community that this is the view that the Commission is going to take. And probably over a period of time, you can move to a system of settlements.
I have a question for you. There are, when you look at settlements, the way the Madras High Court and the Agarwal case in the Delhi High Court have moved, those were settlements between the party, the informant and the opposite party. And of course, what Peter discussed was, of course, in the context of settlements which the opposite party does with the Commission. What the audience would welcome would be your comments on both these forms of settlement, and in what way we could have them institutionalized if at all.
First of all, I don't speak for the Commission. Under the present legal architecture, there is no ground for the law doesn't provide for settlements. So we cannot pass a regulation, as you were saying, give any guidelines or any regulation for settlements. So it would be a bit, and taking from what Madam Prabhu just now said, we have to keep our eyes focused on the opening sentence of section 27. I'll leave it at that. But yes, this is a thought of the entire this conference, and there have been a lot of other views coming around this. There have been a lot of letters coming to the Commission, and on various fora people are talking about settlement. But as of now, it is not on the radar.
Going back to the most important topic, which was the of competition compliance, which was the first topic we're now taking it up towards the end. The CCI, as the chairman mentioned this morning, the CCI is moving towards a competition compliance toolkit, which the CLPA is preparing for the commission, and hope it gets the blessings of the commission once it is prepared. But compliance is an important, and to what extent, so when a company which has a robust compliance program has come to you for maybe is being under investigation, to what extent does that change your view in terms of how this company should be investigated and whether or not the conduct may have been inadvertent or intentional?
A company with a robust compliance program will obviously have a better, precise and very focused evidences which can establish the cartel conduct, and definitely if it is so, probably